Okay, good afternoon once again. So this is the next video for the continuation of our discussion. Miss Kristal Canatoy.
Okay, pa-slide ko sa PPT, page 31. So for the continuation of my report, C, delay. The delay referred here is the legal delay. The general rule is that no demand, no delay. As a consequence, if the creditor did not demand the performance of the obligation, the creditor cannot go to the court to sue the debtor, hence demand is necessary. So for this topic, if the creditor did not write a contract against the debtor, it means dili siya valid pag mag-adto siya sa court. Ways to demand the fulfillment of the obligation we have here. First, the juridical demand. Juridical demand. The creditor goes to court to fix the period within which the debtor will perform the obligation. So, in the juridical demand, it is also said that the debtor will perform his or her obligation to the creditor. Second is extrajuridical demand. The creditor writes a demand letter or demands orally. So, example of this is if I am the creditor and Miss Oscel Cabungcag is the debtor, I will write a contract that Miss Cabungcag should pay her loan according to the said date in the contract. So, uh, next is contravention of the tenor of the obligations. Next, baba po please sa slide. It is the failure to perform that which is the incumbent upon him, the non-performance or negligence of the party to fulfill his duty is liable for damages. Next slide, please. So, 5. Different kind of damages. Page 32, please. So the different kinds of damages has 6 types. First is actual or compensatory damages. So when we say actual or compensatory damages refers to the money paid to the plaintiff to cover for the damages caused by the defendant. Other of damages also exist, and these include property, property damage, lost wages, medical care, and many others. The actual or compensatory damages has 3 types, which is the economic damages, non-economic damages, and punitive damages. So B, moral damages. Moral damages are a type of extraordinary damage that compensate an employee for mental distress or other intangible injury uh, arising from the employee's breach of its duty of good faith and failing in the manner of dismissal. So example of moral damages is include physical suffering, mental anguish, fright, serious anxiety, wounded feelings, moral shock, social humiliation, and similar injury. For the next one, the nominal damages. Nominal damages are recoverable where a legal right is technically violated and must be vindicated against an invasion that has produced no actual present loss of any land or where there has been a breach of contract and no substantial loss of property. actual damages whatsoever have been or can be shown. Next is temperate or moderate damages. More damages than compensatory damages may be recovered when the court finds that some uh, loss has been suffered but its amount cannot, from the nature of the case, be proved with certainty. The next one is liquidated damages. So liquidated damages, a contract provides a specific amount to be paid as damages in the event of future default or breach of contract. Example of this would be a contractor that failed to complete a construction project on time and is changed daily until the project has been finished. So the contractors must finish his project immediately. So the last one is exemplary or corrective damages are imposed by way of example or correction of the public good in addition to moral punishment. Liquidated or compensatory damages are supported of Article 2233. Exemplary damages cannot be recovered as a matter of right. The court will decide whether or not they should be adjudicated. Example of corrective damages are offensive, malicious, violent, wanton, fraudulent, grossly reckless. So, six different kinds of obligation. In this section, we will only discuss the first four items as these are common in the business. Uh, A, pure obligation. It is in which is not subject to be condition and is demandable at once. B, conditional obligation. It is one where the obligation is subject to a condition. It is demandable upon the happening or non-happening of the condition. Next slide. Um, C, obligation with a period. The happening of the arrival of the period gives rise to an obligation or extinguishment of it. D, joint obligation. In this obligation, there are several debtors and one or more creditors, but each debtor is only liable for his share of the debt and each of the creditors to his share of the credit. It is always presumed that the obligation is joint. E, solidary obligation. In this obligation, each of the debtors is liable for the entire obligation and each of the creditor is entitled to demand the satisfaction of the whole obligations from any or all of the debtors. F, alternative obligation. So alternative obligation is one wherein various prestations are due but the performance of one of them is sufficient as determined by the choice, which has a general rule belongs to the debtors. And last, facultative obligations refers to the obligations wherein the thing is due but another pay in its place. So, Miss Noemi.
Okay, thank you. Thank you, Miss Crystal. Okay, for and now for the continuation of the discussed topic is the Article 1305. So in Article 1305, it is a contract. And a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or render some service. The contract is not actually the paper as defined above. It is the meeting of minds. The instrument is where the contract was written. As general rule, it is the evidence of the contract. So it isn't about it is a contract about distinguished form of obligations. So now the question is, when does this meeting of minds happen or occur? So it takes place when an offer by one party is accepted by another one party. So at that time, there is a agreement between two persons. So to emphasize it, meeting of minds there, it doesn't really mean that it is necessary to that it has a written documentation, because it states that it is just a meeting of minds. But there are some exemptions for that, because there is other types of contracts that really or requires to be written, so that in this area, in this article, the other party accepted the offer without any prescribed requirements or qualifications, meeting at that time meeting at that time that their minds meet there is and meeting at the time, and that their minds meets there is already and when their minds meets there is already a contract or a agreement to that. So now let us emphasize also the word contracts form as an agreement, because there are also type of agreements that cannot be enforced in the actions in court. For example, when you and your friends decided, planned, and agreed to watch a movie today, or to have to go together at some places, and also have beach bonding together, it is still an agreement, but it is not a contract or defined by the article 1305. So an agreement here is broader in contracts, because all contracts are agreement, but not all agreements are contracts. So let's proceed to the article 131318. It is state that there is no contract unless the following requisites concur. So consent of contracting parties. So what are the requisites of this article 1318? First is the consent. Second is the object. Three is the cause. So let's go back again. First is the consent of the contracting parties. Second is the object certain, which is the subject matter of the contract. And the third is the cause of the obligation, which is established. So it is also can be called COC. So let's dissect first the consent. So the word meeting of the minds must be certain is so the word meeting of the offer must be certain, and acceptance is absolute. Consent there defines as the meeting of minds with respect to the subject matter and the cost of the contract. Like for example, um, a guy named Keser Ali offered his car to Rosie for 1.2 million, and there is still no consent from Rosie that she will be going to grab it, to go with it, or to accept the offer. So at this time, question now, does Kazar can withdraw the offer? Yes, because Kazar is still allowed to withdraw with the offer, because there is no consent from Rosie that she will buy and get the offer. There is no still meeting of minds, and or there is no still a perfect decision about the subject matter. So, what are the requisites of consent? Of course, the consent must be two or more parties, because it is a meeting of minds. Second is the both parties must be capable of doing or to give something. Three, there must be no violation of consent. Of this must be violence, intimidation, or fraud. And also, the intent must be stated properly, and the consent must be properly declared by another party. So if Rosie will grab it, then she will need to declare it properly. And second one is the object. Object states that it is certain which is the subject matter of the contract. So the object of the contract may be things, right, or the service. So these are the scenario or example for this. For example, um, the consent is being established between you and your neighbor as the terms and conditions of the agreement, and your neighbor is that your neighbor is liable to pay you the cost of the commodities that you have already declared to her. And the object now is the things or rights and service, which is the supply of the purified water, which is the purified water is also the subject matter of the agreement. And there is a rules, and there is a rules on the object. First is the object of the contract must be within the commerce of the man. This means that the object is capable of appropriation. Second, the object must be lawful. Third is the services as an object should not be contrary to the law, morals, good customs, public order, or other public policy. And the last one is intransmissible rights cannot be the object of the contract. So, and that time for the continuation of the scenario, and then the cost of and then now the cost of the consideration of the agreement is the delivery of the purified water, as it states that it is the reason why parties entered into a contract or obligation, while on the other part of the receiver or to the neighbor is the payment of the amount of each gallon that being delivered. And the third one, and so the other one is the formalities of the contract. So now when we say formalities of contracts, formalities goes to enforceability, the purpose of requirements as to the form of contracts. And contract may be made writing as long as the three essential requisites are present, and it can be also word of mouth or may be implied from the conduct of parties or from the course of dealings between the parties. So when we say, so it can be distinguished in two. First one is the letter A, when the law itself requires that they be in some particular form writing to make them valid and enforceable. It's the sole consolement contracts. And the other one is And the other one is the letter B, when the law requires to be proved by some writing or memorandum of its term, as in those covered by the statute for to frauds in Article 1403 of the Civil Code. So their existence not provable by mere oral testimony unless wholly or partly executed. These contracts are exceptional in requiring writing embodying the terms thereof of further enforceability by action in court. So, so in contract law, to emphasize it, so in contract law, formality is required for large engagement. For example, the sale of land, lease of property over 3 year, a consumer credit agreement, or a bill of exchange and guarantee for contract at some stage must have evidence in writing. So for the next topic is the stages of contract. So stages of contract has has three areas, and any types of conduct undergo stages. If the contract is written, the involved parties may be used their vernacular language. Any dialect can be used in making a contract as long as both parties understand the same. Generally, these are the stages of making a contract. First one is negotiation stage or the generation stage. So in this stage, when we say negotiation, it is obviously the first stage, and it starts with a discussion of an issue in a way that both parties finds it acceptable. And for example for this is when you are going to a mall, you and the salesman are negotiating with a customer over the price and terms of the sales. So at this moment, at this stage, there is still no agreement or the meeting of minds, because it is this stage is just for a discussion and thinking of an issue which is acceptable in both ways. For the second is the perfection or birth of the contract. So at this stage, there is already a meeting of minds, as it as what indicate in the sim, it is here where parties agree upon the essential elements of the contract after negotiation of the terms and conditions. So, and both parties now have already an obligation on the subject matter, and they and obliged to do these things and to offer something with respect to the terms and conditions that being or established by the both parties. So it is the time that parties will now decide whether to accept it or not. Once it is proved, then a contract is made since there is already a meeting of minds, and in this stage the contract is perfected, and therefore both parties must comply. It is just like a also like a sort of like the vows in wedding day. Both parties promise to stay together in terms of conditions, like in sickness and health they will give something to the other party, and for the other party, and that time they will have a decision, and they agreed and they commit to each other that they will do these things. So in the third part is the last part, which is the consummation or termination. When the parties fulfill their obligations, the contract will end or be terminated. So, it which consists of the performances fulfillment by both parties of their obligations, and termination here is emphasized as the end of the contract and agreement. Like for example, Alice met the event and catering coordinator of Wonderland Hotel to inquire about a venue for her debut. The coordinator presented a proposed quotation worth 50,000 inclusive of the function hall and foods, and Alice asked for 20% discount. So these are now became the terms and conditions on the first part, as it states with the first stage of the stage. But the coordinator can only give 10%. So was there at that time there is still no agreement, because it is still a bargaining stage. There is still no meeting of minds because it is just in a discussion. Suppose Alice agreed to the 10% offer and consented all the terms and condition, then there is already a contract. So in this stage the contract is already perfected. Then, after paying the full amount and all obligations were done and fulfilled on the said date by both parties, then the contract now is being terminated, and this is the consummation stage, which all the agreement and contract is now ended. So now, next topic is the characteristics of the contract. So they there are there are four characteristics of the contract. So first one is the mutuality of the contract. It is the validity, performance, or compliance of the contract cannot be left to the will of only one of the parties. The ultimate purpose of the mutuality principle is to nullify a contract containing a condition that makes its fulfillment or pre-termination dependent exclusively upon the uncontrolled will of one of the contracting practice of the parties. So, this type of characteristics refers to the reciprocal understanding or agreement between parties. So, the second one is the autonomy of the contract. So autonomy of the contract, it is the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient. So it is a type of characteristics that both parties can freely regulate their opinions, interests, and create legal terms and conditions and relationship that is which is possible to them. And for the third characteristics is the obligatory force. It is from the moment the parties perfected a contract, they are bound to the fulfillment of what has been expressly stipulated, and to all consequences which, according to their nature, may be keeping with good faith, usage in law, when the parties failed to fulfill the established terms and conditions of the perfected contract, a cause of action for breach of contract will arise. So this is means that whatever the terms and condition that they both establish, they must have to comply it. And now for the relatively of the contract, relatively of the contract means that the contract will entered into by the parties is binding only between to them, the heirs and assigns, except in the case where the rights and obligations arising from the contract are not transmissible by nature or by stipulating or by the provision of law. The heir is not liable beyond the value of the property or the said agreement. So it means a contract can generate rights only in favor to those person, for those two-person who belong to the agreement, and it cannot be favored into a third person. So even the third person is aware of the contract and acted with knowledge, and there is still no proof of contract to him. So the third person has no obligation or the liability of the agreement. So now, for the next topic, topic is the defective contracts and their effects. So it has a three areas for the defective contracts and their effects. The first one is the resistible contracts. Four areas of the defective contracts. And the first one is the resistible contracts. So this contract is a valid contract that has all essential requisites of a contract. But because of injury or damage caused to either of the parties therein or to the third persons are considered defective and thus may be rescinded. Once the contract is cancelled, it is terminated, and the parties will return to their original position as if there was no contract entered into, or if the property or the object of the contract has been deposed or the value thereof shall be returned. So it is entering a contract but has resulted in economic. It is an entering a type of contract that someone enter into it and become, or it resulted in economic damage to one parties or outside the party. So the court can set aside the contract for these reasons. So the second one is, so again, the following contracts of the resistible, going back to it, this will it is can be found when those that are entered into guardians whenever the wards whom they represent suffer lesion by more than one fourth of the value of the things which are object thereof. Second is those agreed upon in representing and absentees if the latter suffer the lesion stated in preceding number. Three, those who undertaken in fraud or creditors when the latter cannot in any other manner collect the claims due to them. And four is those which refer to the things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or competent judicial authority. Five is all other contracts especially declared by law to the subject to recession. Second one is the voidable contracts. So the voidable contracts, these are the types of contracts that are valid until annulled. So until annulled. Article 1390, the following contracts are voidable or annullable even though there may have been damage to the contracting parties. So this will happen if those where one party is incapable of giving consent to a contract, and second, those where the consent is violated by mistake, violence, and intimidation. And for the third one is the unenforceable contract. So when we say an enforceable contract, it is a contract that cannot be enforced unless ratified due to any following reasons. First one is when a contract was entered into a name of another person by one who has not been given authority or legal representation, or who has acted beyond his powers. Second is the contract did not comply with the statute of frauds. In statute of frauds, some transactions must be in writing to effect into enforceability, such as the sale of the real property, sale of goods, chattels, or things if the price is not less than 500 pesos, and an agreement to lease for more than 1 year. If these contracts are not writing, the other party may not sue the one who violated in for the court. So this type of contract is a type of violation that when two partners agreed into something, and then the other one did something that without the authority of the other parties. So this is an illegal action, illegal representation, because the other the other party has acted beyond his power. And for the last one is the void an existent contract. So this type of contract, it is equivalent to nothing and has absolutely one thing in civil effects. It cannot be validated either by ratification or prescription, although a void contract has any of its terms have been performed. An action to declare its inexistence is necessary to allow restitution of what has been given under it. So it is a very common example for this is a contract between a drug dealer and a buyer, which means that neither of the parties can go to the court and enforce the contract because it is an agreement to carry out an illegal action or illegal act, which is prohibited by law, good morals, and the public policy, as it states there below that the following contracts are inexistent and void from the beginning if those who cause object or purpose in contrary to the law, those are absolutely simulated or fictitious, those who cause object did not exist at the time of the transaction. Fourth is those who object is outside the commerce of men. Fifth is those who contemplate an impossible service. Six is those where the intention of the parties relative to the principal object of the contrary cannot be ascertained, and those who expressly prohibited or declared void by law. And that would be all for the week 4 to 5. Again, thank you for listening. And again, we hope that you have gained some learning about our discussion. And again, I am Noeme Jane V. Burlas.
I am
And I
Kristal
am
Ethel.
Oscel in
And again, we are the group 4.